Hello, my name is John Lande. I am an emeritus professor at the University of Missouri Law School, and this is a presentation of a brief example of a simple framework for litigation interest and risk assessment from the book Litigation, Interest, and Risk Assessment: Help Your Clients Make Good Litigation Decisions by Michaela Keet, Heather Heavin, and myself, John Lande, published by the American Bar Association. And we're going to walk through the fact pattern of the case from the book, and I'm going to basically read this to you and you can follow along as we go along. And we have a case of Maria Planter, who's filed a lawsuit against the Defrank Construction Corporation, and she's claiming $2 million in damages for personal injury because of entering a construction zone as a member of the public and suffering injuries when she was hit by rocks from a construction blast. She is claiming $500,000 for past losses and $1.5 million for future losses. The defendant, Defrank, has offered to settle for $675,000 should Planter accept this offer or continue in litigation. Now, her lawyer has identified the following key risks at trial. First one is assumption of risk. Defrank has pleaded an affirmative defense that it had posted signs warning the public not to enter the construction site. The lawyer, plaintiff's lawyer, believes that there's a 70% chance that Planter will defeat the assumption of risk defense, but a 30% chance that she would lose her case on this basis. A second issue involves the standard of care. There's conflicting evidence about whether Defrank met the industry standard of care in using procedures to limit the dispersion of debris. Planter's lawyer believes that Planter has an 85% chance of proving that Defrank did not meet the standard of care, but there's a 15% chance that she could totally fail to prove a breach. Now, a third issue relates to causation to the extent of damages. Planter had pre-existing back injuries, and it's unclear whether some of her claimed damages relate to the pre-existing injuries rather than having been caused by the construction blast. And her lawyer estimates that, assuming that Defrank will be held liable, there's a 90% probability of proving $500,000 in past losses and a 10% chance of proving $400,000 in past losses. And the evidence about causal connection between the initial injury and the past losses is strong. And the damages about future losses are much less certain. And the evidence is much weaker when looking at the projection of future loss because of the pre-existing back injury and the likelihood that Planter would have suffered a disability anyway. Her lawyer estimates that there's a 20% probability of proving $1.5 million in future losses, a 30% probability of proving $1 million, and a 50% probability of proving $500,000 in losses. The lawyer believes that these are the only major uncertainties in the case, and given these assessment, Planter has a 60% chance of establishing Defrank's liability. And we get the 60% by multiplying the 85% and 70% up above, and we get 59.5%, which we're rounding to 60%. And here's the 70% and the 85% that I mentioned. The lawyer also suspects that Planter is concerned about various intangible costs of litigation, such as the possible humiliation that she may experience at trial and her fear of losing the case and recovering nothing after an exhausting trial. The lawyer is confident that Planter would accept $75,000 less than any expected net recovery, that is, after deducting future legal fees and expenses, to settle now and avoid trial. So based on these facts, how should Planter's lawyer evaluate the case? So here we have a set of calculations and the simple framework presented in the LIRA book. And you'll see that there are two stages. First stage is determining the expected value of the court outcome. The second stage is calculating the net expected value of the court outcome. So the first stage involves 3 steps: estimating the risk regarding liability, estimating the damages, and then determining the expected value of the court outcome by multiplying the probability of liability in step 1 by the amount of estimated damages in step 2. And this is commonly known as the value of the BATNA. And then in stage 2, you estimate the value of the tangible and intangible costs of proceeding to trial. And then you calculate the net expected value of the court outcome by deducting the estimated costs in step 4 from the expected value in step 3. And that produces the bottom line, which is a really important value in settlement. Now, let me just mention in terms of where these numbers come from that were described in the facts and that we're going to work with here in this example. These are estimates that the lawyers come up with, and you're going to see that we're going to have also estimates, not only the plaintiff's calculations, but also the defendant's calculations. These are not dropped out of the sky from heaven with certainty. Lawyers have to make their best estimates, and these estimates will change during the course of a case. And the estimates that you're going to see here are ones where they occur late in the case. At the beginning of the case, each side is going to have much more optimistic estimates. All right, so let me just walk you through this. So in step 1, Planter estimates that there's about a 60% of proving liability, 85% on assumption of risk, 70% on standard of care, coming up with a 59.5%, which we're rounding to 60%, as we showed before. Now, you also want to look at the defendant's perspective. You may be representing the defendant, and you also, even if you're representing the plaintiff, you want to get a sense of their perspective. And so the defendant estimates only a 48% probability that the planter can prove liability, and that's based on an assumption of 80% on the assumption of risk issue and 60% on the standard of care. You multiply the two numbers, 0.8 and 0.6, and you get 48%. Okay, so that's the step 1 you saw before. So the step 2 is you want to calculate the probability adjusted damages. And so first you're going to see the table with the plaintiff's calculations and then the defendant's calculations. So this is just plugging in the numbers that we presented before. So you can see that that the past losses, Planter's lawyer has estimated that there's a 90% probability of proving $500,000, a 10% probability of proving $400,000. You multiply the 90 by the 500,000, the 10% by the $400,000, and you get respectively $450,000 and $40,000. And you do the same thing with the future losses. So you have the 3 values that were estimated and the probabilities for each of them, and that comes up with 20% of $1.5 million is $300,000, 30% of $1 million is $300,000, and so on. And then you add all these factors up together, and what that means is that the plaintiff estimates that the likely trial result would be an award of $1,340,000. Again, all these numbers are based on the estimates that the lawyer makes, and the lawyers may, and indeed often do, vary the estimates so that it may be higher or lower than this. So this is just a single estimate. This is not a guarantee that this is, or an expectation with certainty that this is going to be the result at trial. By comparison, take a look at the defendant's calculations. Again, plugging in the numbers that for their calculations. And again, we've obviously simplified this for illustration. The defendant estimates that there's only an 80% probability of proving $500,000 and a 20% probability of proving $400,000, and so on. In the same way, you multiply the amounts times the probabilities, you get the probability adjusted damages, you add them all up, and by the defendant's calculations, their best estimate is that the plaintiff would get an award of $1.23 million. So now we go to step 3. And you want to estimate the expected value of the court outcome. So in step 3, you have 60%, which we saw before, times $1.34 million. And the expected court outcome, the net expected court outcome by the plaintiff is $804,000. The $1,340,000 assumed a certainty of winning, but planter assumes that there's only a 60% chance of winning, so you discount the $1.34 million by the 60% to get the $804,000. By the same token, the defendant makes their estimate, its estimate of a 48% chance that the plaintiff will win, with multiplying by $1.23 million, which is their expectation of what the damages would be if the plaintiff wins, and their net expected court outcome is $590,000. Now, that's step 3. This is basically what you think that would happen if you went to court, also known as the value of the BAT, the best alternative to a negotiated agreement. Step 4 involves deducting the tangible costs. So the plaintiff figures that if they went to trial, there would be an additional $50,000 in legal fees and an additional $12,000 in legal expenses, such as expert witnesses. And so if you deduct the $50,000 and the $12,000 from the $804,000, the estimated expected value net of tangible costs is $742,000. In other words, if you just look at the dollar amounts, the plaintiff would be, under these assumptions, she would be just as well off to accept a settlement today of $742,000 as compared to going to trial and getting a verdict of $804,000 based on all these assumptions. And here in this table below it, the defendant makes a similar set of calculations, except from the defendant's point of view, they're paying. So here you're going to see they're estimating that their legal fees would be $55,000 and their future legal expenses would be $10,000. So you add those figures to their $590,000, which you saw up here, to come up with an expected value net of tangible costs of $655,000. So from their point of view, it would be worth it, just looking at the dollar amounts, to pay $655,400 today, as opposed to going to trial where they might only get an award against them of $590,000 and $400. So here's the complete set of calculations in a single table. You look at, and these just, well, these include the figures that we've looked at so far, except we're just adding here the intangible costs. So as we noted before, the plaintiff has decided that it's worth it to her to take $75,000 less to settle and avoid the humiliation and the worry and the anxiety. So if you deduct that $75,000, her net expected value of court, or really what's known commonly as the bottom line, is $667,000, deducting $62,000 and $75,000 from the $804,000. And from the defendant's point of view, their intangible costs, which they value at $50,000, you add that in as well. And so that would give them a net expected value of court outcome of $705,000. What that means is that $675,000 would be in what is called the zone of potential or possible agreement. So that would be better than the net expected value of going to trial for planter as well as for the defendant. The plaintiff would receive more than her bottom line, and the defendant would be paying less than its bottom line. Now, it's important to understand that these figures, as I mentioned before, are just assumptions. And indeed, the assumptions here are designed to show a zone of possible agreement where it would be worth both parties' while to settle. Normally, at the beginning of the case, each side is a lot more optimistic. And what happens is over time, they learn more facts and they become more concerned about losing at trial. And so they become more willing to settle and their numbers may become a lot closer. So this is an illustration of how one might use a very simple framework. It's important to understand how to use this framework, and this is a check on one's judgment. Lawyers normally, many lawyers don't use a kind of mathematical calculation like this. They use their gut. They may think about other cases that they know about, that they've read about, that other colleagues have told them about, and they'll make some rough estimate. And sometimes those rough estimates, based on all those factors, are pretty accurate. And what this simple framework does is it provides a check. And so if there's a real difference between one's gut estimate and the calculations that one makes using this framework, then it should prompt the lawyer to think about where their assumptions may be wrong, either in terms of any of the figures plugged into these calculations, or perhaps their gut estimate. And it's really important to remember that each side tends to have cognitive and motivational biases that tend to make them overly confident. And this is one reason why a large number of cases go to trial where one side or the other gets a result at trial worse than the last side's offer. So what you really want to do is make sure you're not being overly optimistic, and so that you do not get a bad result. You do not, if you're a plaintiff, want to end up at trial with a worse result than what the defendant has offered, and vice versa. The defendant does not want to end up paying an awful lot more in a trial verdict than what they could have settled from the plaintiff. So hopefully this helps you understand how you can assess the value of a case.